Prosecuting attorneys have so much influence over grand juries, they could get them to indict a ham sandwich. That popular quote by a New York judge shows the lack of independence grand juries now hold in this country. Since no cameras are permitted in grand jury rooms and its proceedings are truly behind closed doors, most of us know little about its operation. But there is a sliver of hope that some of the abuses of the grand jury may be in for a strong smackdown by the U.S. Supreme Court. The High Court recently heard arguments in the case of Cayley versus United States. This case challenges the current Justice Department practice of seizing a defendant's assets upon indictment. Naturally, this makes it nearly impossible for the accused to pay for legal services in order to defend themselves in court. The hearing of a grand jury in serious federal crimes is guaranteed in the first sentence of the Fifth Amendment. The founders saw the grand jury as protection against an overzealous prosecution. Before a citizen could be arrested and made to stand trial with all the burdens such events would entail, the people, in the form of the grand jury, would have to rule that the evidence did in fact support the charges. The protection of the grand jury thus ensured prosecutors did not misuse their charging powers. But those lofty ideas seem long ago and far away in terms of how the grand jury operates today. You can imagine how formidable the government is as an opponent in any legal proceeding with the advantages of nearly unlimited resources. Indeed, over 90% of federal defendants plead guilty rather than go to trial. Does the Constitution really permit the government to make a trial inaccessible to the remaining 10% who can afford a decent defense? In order to use criminal asset forfeiture and keep someone's cash, the federal government generally has to prove beyond a reasonable doubt the underlying criminal charge and that the money was acquired as a result of proven criminal activity. Under current law, a grand jury indictment in and of itself is sufficient to allow the freezing of assets. Prosecutors make serious allegations against potential defendants, then question the witnesses without cross-examination. Defense attorneys are not even allowed in the courtroom, and these targets of prosecutors have no right to challenge evidence against them or present evidence in their own defense. They don't even have the right to know they are a target. What horrible people we would all be, and if an attorney could selectively question us without the opportunity for cross-examination. This new use of the grand jury indictment, not to ensure the propriety of charges, but to head off any effective defense against them, turns the grand jury from the people's protector into the prosecutor's weapon. As of last year, the Justice Department had almost $6 billion in its asset forfeiture fund. These spoils are spent by and large on more resources for law enforcement and with great latitude. The motivation to make sure that people lose their money has become quite personal for the agencies involved because they get to use the money themselves. These seized assets should rightly be placed in the U.S. Treasury instead of the accounts of the Justice Department. Do constitutional notions of due process and the right to a fair trial allow these practices? We'll soon know what a majority of Supreme Court justices believe to be the answer.